Yep, I know. I know. Go ahead. Say it. Everybody just say it real quick. Go ahead. So, to fix my freaking mute problem, I got a little box to fix my freaking mute problem, which I just spent the last 10 minutes trying to fix so that it fixes my freaking mute problem. It didn't fix my mute problem. It just didn't. It just didn't. It just flips to mute. I don't know why it flips to mute. But I think I got Twitch set up so that the text messages will show up on screen now. We'll see. I don't have my mute fixed, but I might have my Twitch fixed. I don't know. They just don't make enough coffee some mornings. You know what I mean? Went to Cartel. Or was that Cartel a couple hours ago? It's a brewery in Lancaster. No, I don't work there. Hi, Terry. But it's a good brewery. Good brewery. If you ever go near Lancaster, and I think it's only in Lancaster, and you are going to consume any alcohol, go to a brewery that has Jimmy Juice because it's delicious, and you can only get it in Lancaster. So there's this Sickman's Old Mill place you go tubing. It's just a fun place. They make this vodka-based Jimmy Juice that is outstanding. Cartel used to have it, so we went there just for Jimmy Juice last night, and then they don't have it there anymore. But if you're ever in Lancaster, get Jimmy Juice. Just write that down somewhere so that you remember. I have an update of how I screwed something up majorly. So I've been showing you these RICO cases in Georgia, right? And you're going to understand why I messed up. You're going to understand because you watched the same thing I did. And nobody has said, wait, that's wrong. So there was a set of RICO cases in Georgia. Nope, puzzle, no. And we saw Glizzy, you remember Glizzy, Glow? Okay, if you don't remember, they were in jail for like 2 years without charges, without anything. No one knew what the charges were. They weren't indicted by the grand jury or anything. They had no bail. It was 11. Just stay with me because I'm about to tell you there were 11 defendants for these crimes, and all we heard from the judge was how they were violent crimes and very serious crimes. So no one was allowed out of jail, no one was charged, no trial, no attorneys. Well, some of them had attorneys, but they were just stuck in jail, period, until the prosecutor's office decided to do something, anything. And my mic volume is low. Why am I so low? What does that mean? Is it my mic volume low? Anyway, so then there was another one. Here's why it's confusing. Oh, good, because it's up the whole way. It's just max. Then there was another group of RICO cases with 17 defendants. Okay? All right. So that part I only found out today. So you might remember me saying a couple times before when we were watching these people in front of the judge, there were 17 co-defendants. They're all stuck in jail. They've been in jail, blah, 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 blah. Well, there's 2 different groups of RICO cases in Georgia. That's why it was confusing. The second one were nonviolent crimes. They were delivering drugs into the prisons with drones. Okay? The first one were violent crimes. And let me just tell you, when I say they were violent crimes, they were violent crimes. They were from a an offshoot of the Bloods, the gang, the Bloods, the MLP, Money something Power. Can't remember the L. Doesn't matter. It doesn't matter. There was this big gang in Georgia, and they all they all were charged with like 155 counts, RICO and gang laws and murder, aggravated assault. When I say murder, I don't mean they were shooting each other. I don't mean they were shooting another gang. There were 45 innocent victims. Some of them were children in this gang activity. It was bad. What they did was bad. So now I don't feel so bad about them sitting in jail with nothing for so long, because they're all in there for life now. None of them are ever getting out again. So I guess in hindsight, it doesn't really matter, right? Because they got life. They all got life. All 11 of them in the first pled. April 4th and April 11th, I think, which they didn't stream because I didn't get it. And they all got life. Well, now there's the second RICO cases going on, and these are non-violent crimes. Nobody got injured. I guess drugs is they were delivering drugs into the prison, and there are 17 of them, and they're just sitting in jail right now, the same thing, waiting for something to happen. So we're going to see 2 of them get arraigned today. We've seen some of them get arraigned in the past. So like Glow, Glizzy, those were from the first one. Those are the gang. These guys, the Dunn and not Warnock, can't remember, Maribel. Dunn and Maribel we're seeing, these are from the second one. And a couple of them that we've seen in between were from both. And that's why they were so confusing. Okay, I have to check. I have to look at chat now. Hold on, guys. Some people are saying my mic is fine. Some people are saying my mic is low. If you would all just agree, then I can fix it. What if you are all saying 2 different things? Hold on. Kelly started it. Why are you so low? I think what Kelly meant was that my mic was low. I think. CJ, that I'm fine. Mel, I was low. Mel put her earbuds in and she's fine. Volume is fine. Volume is very low. I can barely hear you. Mic volume is okay. Guys, I don't know what to do. Kit Kat can barely hear me. Now it's an emergency. I'm going to start this clip in a second and see, so some people are, I'm going to start this clip in a second. All of you who had to turn me up, you're about to get your ears blown away. Maybe we are all high. Guys, I don't know how to fix it for everybody because you're 50 and 50. I'm about to start the, don't worry, it's not gonna autoplay. Hold on. I'm about to start this clip. I'm about to press play. Okay, but the thing is, my mic volume is maxed right now. I can't, there's another setting I can turn up, but remember I said I'm never touching that again, never. So, hi Jay. My microphone is maxed. See, look. And now it's maxed. And now it's maxed. I can't make it any higher than that. And there's nothing on the actual microphone to touch. I mean, I'm touching it, but I'm going to press play. Everybody ready? Everybody got your volumes set so you won't. I'll press play for a second and then I'll pause. I'm clear to you, Anna, but 50% of the people I'm not. But that's okay. You don't need to hear me. You need to hear this. I'm going to press play for a second so that you're not blown out of the water and you can adjust. Here we go. Ready?
Zoom to
Okay. I just pressed play for a second. Now you can adjust. I'm giving you a second to adjust. Josh, go make me some breakfast while you're just hanging out in the background. If you're not going to do anything, you might as well make me breakfast. Just kidding. I just had a chicken finger. I'm good. Breakfast of Champions. All right, here we go.
spell your name for me so I can put you in the system.
Sure. The last name is Apt. A as in apple, B as in banana, T as in tomato. My first name is Elliot, but everyone calls me Jay, which is my middle name.
Okay, thank you.
All right, and the gentleman at the jail, what is your name, sir?
Antonio Marable.
All right, and whoever's there with you, is Mr. Dunn there with you? Did you bring
Not at the moment, I don't think.
All right, well, I want to do these at the same time since they're co-defendants. I don't want to do it twice.
Different, I have a different argument for both because they're co-defendants, but
I got
it's
you.
going to be different.
I understand.
Okay, let me get that one.
Yeah, can you get Mr. Dunn as well? I want to do them at the same time.
Yes, sir, I'll get it.
All right, thank you.
Okay, ready for the round? Yeah, 2012 for that one.
No, you're fine. You're good. You're good. I know how it is, Trevor.
Thank you. It's good, but it was still some of the bonus. So I'm strong, I'm pleased, the whole stuff.
Mr. McClendon, just as a housekeeping note here, I see Mr. Warnick is still listed on this, but he's out. Is that correct?
Yes, Your Honor, I filed a substitution of counsel.
Got it.
What were those? I got this is just coming. Okay, Judge, I have Lavaris done also.
All right, very good. Mr. Marvell and Mr. Dunn, can you both see me and hear me this morning? All right, excellent. I have both of you on my bond calendar today. This is case number 25R127. Mr. Maribel is got the suffix D, and Mr. Dunn, you are assigned the letter G. Both cases have been assigned to me. I'll note for the record that Mr. Maribel and Mr. Dunn are appearing remotely today from the Telfair County Jail via Zoom, our video conference platform. Mr. Jay Apt, representing Mr. Maribel. He is with us as well via Zoom. And also present here today is Mr. McClendon, representing Mr. Dunn. I am present today in the Telfair County Courthouse. These two cases are on my bond calendar. And Ms. Stanley, by the fact that we're all here, I presume the state is opposed to bond on both of these two gentlemen. Is that correct?
We are.
All right, go ahead and give me your reasons, and then I'll hear from the attorneys.
The state is going to be opposed to bond today, and since we have two defendants here, I will let you know which of my argument is the same for both and which is different. So for Mr. Maribel and Mr. Dunn, they both would not be entitled to bond because this case was indicted as a special presentment indictment, and the 90-day rule would not apply. They are both charged with 3 counts of racketeering activity, possession of marijuana with intent to distribute, 10 counts of gang activity, 2 counts of illegal use of an unmanned aircraft system, and 2 counts of criminal attempt. Under the gang statute, which is 1615-4, it does require the court to set an increased bail for gang charges and special conditions that the defendants should not have contact of any kind or character with any other member or associate of a criminal street gang. I will note for the record that we have been here with several other co-defendants at bond hearings. Bond has been denied for all of them as well. For Mr. Maribel, I did see that he has a couple of misdemeanors on his criminal history. For Mr. Dunn, I did look at his history. It appears that he has a sale of cocaine and a possession of cocaine with intent to distribute from 2009. Without getting into the facts of the case other than what I have to for the bond hearing purposes, this case does involve direct contact with inmates at Telfair State Prison and using drones to fly in illegal drugs and other items of contraband, which puts the security of the prison and all of the inmates and guards there at risk. We are opposed to bond today because we believe that both of these defendants pose a significant risk to commit other felonies pending trial. We also believe they both pose a significant threat or danger to the community, being in possession of these drugs and items of contraband, being in contact with inmates at Telfair State Prison, and trying to get that contraband into the prison.
All right, well, I'll hear from the attorneys at this time. Mr. Apt, I'll hear from you first, sir.
Thank you so much, Your Honor. My client was originally arrested in December of 2023 on this case and then made bond. And then, of course, as the state pointed out, there was a grand jury presentment and new charges were brought, and he was rearrested on July 24th of 2025. I think it's worth noting that in the year and a half that he was on bond, he committed no criminal offenses, did not have any contact with any gang members, committed no violations of his bond conditions, and complied with all of this court's orders. So he successfully was a good candidate for bond and met all of the Ayala factors for that year and a half that he was out of custody. He is 24 years old, Your Honor. He has lived at the same address pretty much his entire adult life. That's on Davenport Road in Rail, Georgia. He lives there with his family, I believe his grandmother. It is a significant indictment, and while he does have a couple of he's got a prior misdemeanor and I think a prior felony that he took first offender on, Judge, he has a lot of good things in his life. He graduated high school in 2019 from Washington Wilkes in Washington County. He works full-time, or had worked full-time until he got arrested. He's a licensed tattoo artist and was successful in that career. He lived with his godmother who had adopted him. He was originally born in foster care, and or he was originally born and then put into foster care at a young age. But But, Your Honor, I mean, the state is proffering facts, and I understand that they're allowed to do that, as can I, but I want the court to remember that he's presumed innocent. These are nonviolent offenses, and quite frankly, given the fact that he spent almost a year and a half out of custody without any incident, I think that shows and demonstrates to this honorable court that he would do the same if a reasonable bond were to be granted. So I ask the court to consider bond in any amount it sees reasonable and fit with any other restrictions the court might want to put into place. For example, the state pointed out that part of the statute requires him to not have contact with other gang members. I think an ankle monitor and house arrest would be an appropriate remedy to ensure that. And I'm happy to have him pay that at his own expense if the court would allow it. So I thank the court for its time, remind the court of his presumption of innocence, and the fact that he was able to meet and comply with all of the court's orders for his previous bond. Thank you for your time, Your Honor.
Thank you, Mr. Apt. Mr. McClendon.
Yes, Judge. Mr. Dunn was picked up last year, I think in October, for almost the exact same charges. I think it was communicating with the inmate without warden's permission, some gang charges, and possession of marijuana. He was picked up down in Savannah while he was driving one of his 18-wheelers. He has 2 trucks, his own company. He was picked up by the U.S. Marshals down there. He didn't even know that there were warrants out for his arrest. His statements to the United States Marshals were, "If I would have known, I would have turned myself in." He was picked up and got bond at the time. He's now re-indicted with new charges, and he was contacted again with United States Marshals, Agent Farlow, and Mr. Dunn reached out to me, and in return, I reached out to United States Marshals and arranged a drop-off at the Telfair County Jail. I picked up Mr. Dunn, we took him there together, me and Mr. Dunn, dropped him right off to United States Marshals and turned himself in. So, you know, he's not a flight risk. He does have the past, 2009 possession of cocaine with the intent, but since then, Your Honor, had no issues at all. And like the other attorney said, Mr. Dunn, since he had bond of last year, no issues at all. He's not a threat to the community. He's not going to intimidate any other witnesses. He has, you can put in the bond conditions that he can't have any contact with any co-defendants. And I think he should get a bond, Your Honor, so he can participate with his defense and help out with his family. And it must be noted also, Your Honor, that he lives in Washington, Georgia. Other than what he's charged with here, he's never been in Telfair County in his life. So, Your Honor, I don't think he's a flight risk, dangerous community, committing further felonies, or intimidating any witnesses, Your Honor. We ask for a reasonable bond.
And Judge, if I may add one thing.
Go ahead, Ms. Tim.
I know during the beginning stages, Mr. Mitch Warnock was going to represent Mr. Dunn. And I know Mr. McClendon said he had filed a substitution of counsel. I will say, just so that we have a clear record here, I had talked to Mr. Warnock for a period of time to try to arrange for Mr. Dunn to come and turn himself in. That never happened, and the warrants had to be turned over to the marshals to get him. So I would argue he would be a flight risk. He knew he had warrants at that time.
And Your Honor, just on my behalf, when Mr. Dunn contacted me, I immediately reached out to United States Marshals. They gave us a time and a date to turn himself in, and we did.
All right, Mr. Maribel and Mr. Dunn, there's a couple of things I want to get on the record and address you both directly. I do not recall the original indictments, the separate indictments. I don't know if they were assigned to me or if that we had met before on a previous bond. I don't recall, and it doesn't really matter. But there's a couple of things, several things that I want to get on the record. As one of the attorneys has already said, I think it was Mr. Apt already said, today is not the trial. I'm not here today to get any deeper into the facts as are necessary to make an informed decision about bond. There'll be a time and a place for all the facts to be hashed out. But as some judges and lawyers say, the facts aren't relevant at a bond hearing. Well, I wouldn't go that far, but it's not proper or appropriate for the court to go asking a lot of questions about who did what or who didn't, or whether there is sufficient evidence to convict you or insufficient evidence to convict you. I don't have any idea at this point.
Pause. I should have said that. Sorry. He's not talking about Raphael Warnock. He's just not. He's talking about somebody else. I double checked. I did. I looked it up right away as soon as I heard Warnock. I was like, what? No way. It's not him. That would have been very cool, though.
All I have in front of me at this point is this superseding or this new indictment, the RICO indictment. In the eyes of the court, they are simply allegations made against you, against you both. The only issue before the court today is whether either or both of you meet the statutory requirements for a bond under Georgia law. There's essentially 4 requirements, and I'm sure your attorneys have already gone over this with you. And I'm going to touch on them. I haven't heard anything to make the court overly concerned about either of you being a flight risk. There seems to be some disagreement or question about Mr. Dunn's activities there with Mr. Warnock. And both your attorneys have done a very good job of pointing out to the court the positive factors that both of you were out on the previous indictment, out on bond for quite some time before the new indictment. And I haven't heard anything to indicate there were any violations while you were out on bond. Now, I think Ms. Stanley touched on this. I don't even know how many total co-defendants there are. I've lost track of how many there are. And I have not granted any bonds at this point. And I'm going to deny both of your bonds for the same reasons as were stated by the state and in all the other cases. This is my first experience with a RICO case, and let me tell you both, it's a handful. So I am going to deny your bond for the reasons stated by Ms. Stanley. Ms. Stanley will get me an order. I will also instruct or notify everyone that as I've done, I've tried to do, and all the other co-defendants, is I am acutely and keenly aware that the two of you have been held, as your attorney stated, without bond on this new indictment. That means you go to the top of the list. And I don't know how all this is going to shake out, but I just want you both to hear it from me that I am aware of the fact that both of you are being held without bond, as well as all the other co-defendants. And simply put, the court is going to do what it can to move these cases. They're going to move. I just don't know exactly when the two of you will get to trial. I cannot try all. How many are there now, Ms. Stanley?
There's 17 total. I know that we have a term coming up in December. We are going to do a motion to sever.
Yes.
Because we couldn't fit that many in here at one time.
Well, I simply do not have the resources or the ability to try 17 co-defendants at the same time.
You got this, Judge.
In a previous life, Mr. McLaughlin and I took a lot of appointed cases from the United States District Court for the Southern District of Georgia, and the Southern District of Georgia U.S. Attorney's Office was enamored with multi-co-defendant conspiracy cases. But we don't have that ability. We can't do 17 at one time, and it's going to just have to work its way through. But that's all I know to say at this point. Get me an order, Ms. Stanley, and that will conclude this case for today. So you are all excused. Thank you.
Thank you, Your Honor.
Thank you, Judge.
But I'm here. I don't want, I'm waiting for them to.
Okay, from the jail, you are excused as well, and you can terminate the connection. Thank you, gentlemen. You are excused. Mr. App, nice to see you, sir. Mr. McClendon, always good to see you.
See you too, Judge.
Likewise, Your Honor. Thank you so much.
All right. All right, that takes care of that. All right, Ms. Cameron, you want to start back up with some of your cases?
I'm done with mine.
Oh, you're done, okay. Mr. McLaughlin?
Plus, he probably would forgive me if I didn't let him go next.
Oh.
Come on.
Where you want to start, Mr. McLaughlin?
Your Honor, we can start at the top, Derek Downs, position number 1.
All right, Mr. Downs. Come on up. All right, this is position 1 on my calendar, 23R179-MJ, State versus Derek K. Downs. That's you, sir?
Answer him.
You're Mr. Downs?
Yes.
All right, and for the record, Mr. Downs is at the podium with Mr. McLaughlin. What's your announcement, Mr. McLaughlin?
Your Honor, this will be a negotiated plea. I got to get Mr. Downs. I'm going to be reading it while I get him to initial these. He missed the 11 on the back.
All right, go ahead.
He is going to enter a guilty plea to count 1, which is possession of less than 2 grams of methamphetamine. That is a felony that carries a sentencing range of 1 to 3 years and a fine of up to $100,000. If the court accepts this, he'll be sentenced to serve 3 years on probation. That probation will be subject to drug and alcohol conditions, a Fourth Amendment waiver, and he will be made to pay a fine in the amount of $500. Additionally, the misdemeanor count 2 will be null pros as a condition of this plea.
Anything to add to that, Ms. Stanley?
No.
And I also wrote on the plea sheets that I asked that it be, that he serve this concurrent. He's on probation out of Lawrence County for an offense that, this offense predates that one by several years. I checked.
All right. All right, Mr. Downs, it appears that you and Mr. McLaughlin have reached this joint recommendation with the DA's office. I'm going to have a lot of questions for you in just a moment to make sure that you understand all the details of this. But so far, has everyone said what you expected them to say?
Yes, sir.
Before the court can get to the disposition of the case, the court must first go through a process with you where I ask you a series of questions to make sure that you understand all the details of this plea, but just as important that you understand all of the rights that you'll be giving up if you complete this guilty plea today. If at any point during this process you don't understand my questions or you need some more time to talk to Mr. McLaughlin, just let me know, and I'll give you all the time that you need within reason. Do you understand everything so far?
Yes, sir.
Please raise your right hand. Do you swear or affirm under penalty of perjury that the testimony you give here today shall be the truth?
Yes, sir.
You put your hand down. Mr. Downs, do you understand that you are pleading guilty to count 1 in this case?
Yes, sir.
And is that what you agreed to plead guilty to before you came out here to the podium?
Yes, sir.
And is the sentence recommendation that Mr. McLaughlin stated of 3 years probation, a fine, and all these other conditions, is that what you agreed to before you came out here to the podium?
Yes, sir.
Before the court can decide or determine whether or not to accept this recommendation and this plea, the court must first determine that you are making a knowing, intelligent, and voluntary waiver of all of your rights, that you know and understand what you're doing, and that you're doing it of your own free will. So it's vitally important that you speak up if something happens that you don't understand. According to the plea agreement, we will focus on count 1, which is possession of methamphetamine, which is a felony. It has a maximum sentence of 3 years to serve in prison with a range of 1 to 3. The court does further advise you that you cannot be forced or compelled to enter a guilty plea today. You can maintain your not guilty plea and have a speedy and public jury trial if that's what you wanted, where you would enjoy a presumption of innocence that would remain with you throughout the trial, and the state would have the burden of proving your guilt to the satisfaction of the jury beyond a reasonable doubt. You would have the right to have your lawyer with you at all stages of the trial, where you could confront, question, and cross-examine all witnesses and persons who accuse you. You would have the right to defend yourself and to bring into court your own witnesses and evidence in your behalf. And at your request, the court would issue subpoenas directed to your witnesses to compel them to come to court. You would have the right to testify yourself if you wanted to, but you cannot be compelled to testify nor to incriminate yourself because you have the right to be present and remain silent. You will also have the right to ask the court to suppress any illegally obtained evidence, and if the jury should find you guilty, you would have the right to appeal that guilty finding to a higher court and be represented on that appeal by your attorney. Mr. Downs, do you understand that if you plead guilty today pursuant to this plea agreement, you will be giving up or waiving all of these rights? Do you understand that?
Yes, sir.
Fourth Amendment waiver will be a condition of your probation. Do you agree and understand that as a special condition of probation will be that you shall submit to a search of your person and property at any time of the day or night with or without your consent or a search warrant whenever requested to do so by a probation officer or a law enforcement officer, and if anything is taken, it may be used against you as evidence in a further court proceeding? Do you understand that?
Yes, sir.
And you represented here today by Mr. McLaughlin, is that correct?
Yes, sir.
Have you had enough time to talk to Mr. McLaughlin about this case?
Yes.
Do you need any more time to talk to Mr. McLaughlin about anything involving this case?
No, sir.
Do you have any objections whatsoever about how your case has been handled?
No, sir.
All right, Mr. Downs, is this your free and voluntary plea?
Yes, sir.
Has anyone threatened you or frightened you to force you to plead guilty?
No.
Other than this plea recommendation, has anyone promised you anything to get you to plead guilty?
No.
Are you under the influence today of any intoxicants like alcohol, drugs, narcotics, or prescription medications?
No, sir.
Is your mind clear today?
Yes, sir.
Do you know where you are and what you are doing?
Yes, sir.
Can you read and write?
Yes.
Do you have any questions about anything that has happened up to this point?
No, sir.
If you are not a United States citizen, a guilty plea will affect your immigration status. Mr. Downs, are you pleading guilty to count 1, possession of methamphetamine, because you are in fact guilty?
Yes, sir.
All right, Mr. McLaughlin, see that his plea gets entered.
Mr. Downs, if you don't understand any part of this, just stop me.
All right, I know. Still no Twitch texts. I'm working on it. I'm working hard on it while you guys are watching Georgia court. Actually, we're going to switch now. Oh, no, we're going to finish this guy, then we'll switch. He muted it. Your sound is fine. That's why I'm talking. Because if you hear silence, everybody freaks out. Hardcore. If I told you that we were about to get hit by nuclear weapons, you would not freak out as hard as 5 full seconds of silence on a stream. I'm busy. I'm working on this, Judge. Why are you doing this to me? I don't have time to sit here. Did he forget to press? Is he talking? Is he still muted and talking? I'm going to move it forward. Yep.
And we're ready to, I think we're all ready to proceed.
Okay, let's get him up then. Mr. Clark,
I don't know what
Jermaine Clark.
that last guy, because he muted it.
Okay.
Stand right there for 1 second. 1, 2, 4, 5, 6, 7. And 12. So you got to put it all in.
Give it just a second.
I picked all of the charges in there. And 12. And the fatal part. I didn't see it in there. I probably didn't do it. I didn't. I didn't get that up for legal.
Sure, I will.
Sorry about that.
We'll admit
Threw it right on over.
I didn't see them. These are drug offenses too.
All right, let's get back on the record here. This is my revocation calendar, position number 2, case number 25R235, State versus Jermaine Alonzo Clark. That's you, sir?
Yes, sir.
I'll note for the record that Mr. Clark is standing at the podium with Mr. McLaughlin. This is on my revocation calendar. What's the status of this one, Mr. McLaughlin?
Your Honor, Mr. Clark obviously is before the court for violating his probation. It looks like he expires on 3/5/27. I just relate to the state that we're going to be admitting counts 1, 2, 4, 5, 6, 7, 12, 13, and 14. And I assume the state's going to recommend revoking the balance of that. Like I said, he's got to a 3/5/27, and we're going to ask the court to consider something else.
Is that your recommendation, Ms. Stanley?
Yes, I'm gonna, at the end, I'll just make my argument.
I got you, but you expect your recommendation is going to be revoke the balance?
Yes.
Okay. And Mr. McLaughlin, you and Mr. Clark are going to argue for something else, I presume something less restrictive.
We are, Your Honor.
All right, Mr. Clark, apparently you and Mr. McLaughlin have been discussing your case with the DA's office. And as I understand the situation, you are expected this morning to make the admissions to the counts that Mr. McLaughlin indicated, and then there will be a presentation to the court by both sides about the sentence. Do you understand that the state is going to ask the court to revoke your balance? Do you understand that?
Yes, sir.
And you and Mr. McLaughlin are going to ask for something less. Is that your understanding, Mr. Clark?
Yes, sir.
Very well. Well, before I can get to the disposition, I have to first go through a process with you, Mr. Clark, where I ask you some questions and to make sure that you understand what's happening, but just as important that you understand all of the rights that you have that you'll be waiving if you make these admissions today. If at any point during this process you don't understand my questions or you need some more time to talk to Mr. McLaughlin, just let me know, and I'll give you all the time that you need within reason. Do you understand everything so far, Mr. Clark?
Yes, sir.
All right, as best you're able, please raise your right hand. Do you swear or affirm under penalty of perjury that the testimony you give here today shall be the truth?
Yes, sir.
You put your hand down. You are Jermaine Alonzo Clark, is that correct?
Yes, sir.
And Mr. Clark, do you understand this is a probation revocation proceeding?
Yes, sir.
And do you understand that the state is going to ask the court to revoke your balance?
Yes, sir.
Before the court can decide on what to do with this case, the court must first determine that you are making a knowing, intelligent, and voluntary waiver of all of your rights, that you know and understand what you're doing, and that you're doing it of your own free will. So it's vitally important that you speak up if something happens that you don't understand. I have some preliminary questions to ask you first, however. Are you now under the influence of any intoxicants like alcohol, drugs, narcotics, or prescription medications?
I'm under my prescription medication.
Well, that's fine. I don't need a full detailed medical history, but do those medications in any way affect your ability to make decisions?
No, sir.
Do you know where you are and what you're doing?
Yes, sir.
All right. And is your mind clear today?
Yes, sir.
And Mr. McLaughlin, are you aware of any reason we should not proceed?
I am not, Your Honor.
Mr. Clark, do you understand the court does not have to accept either of these sentence recommendations?
Yes, sir.
Other than the sentence recommendations that I'm going to hear from the state and from Mr. McLaughlin, has anyone promised you anything to get you to make these admissions today?
No, sir.
Has anyone threatened you or frightened you to force you to make these admissions today?
No, sir.
According to this petition, your original sentence was dated March 6, 2024, at which time you received, if I'm reading it correctly, 3 years on probation. Therefore, your original sentence is set to expire on March the 5th, 2027. Do you understand that?
Yes, sir.
Do you also understand that instead of agreeing to your probation being modified, as you're doing now, one way or the other, that you have the right to demand a formal hearing before this court in which the state of Georgia must prove that you have violated the terms and conditions of your probation by what is called a preponderance of the evidence, which means more likely than not. Do you understand that?
Yes, sir.
If you demand such a formal probation revocation or modification hearing, Georgia law guarantees you the right to confront and question all witnesses who testify against you. You have the right to subpoena your own witnesses and evidence in your behalf and to question these witnesses and offer this evidence at the hearing. You have the right to the continued assistance of your lawyer at all stages of the hearing. You have the right to testify yourself if you want to, and the right not to incriminate yourself. You may testify or not, and you personally personally will decide if you testified or not. If you do not testify, which is your right under Georgia law, then the court cannot use that decision against you in any way. Mr. Clark, do you understand that you are agreeing to give up this formal hearing and all of these rights by making these admissions? Do you understand that?
Yes, sir.
Now, you're represented here today by Mr. McLaughlin, is that correct?
Yes, sir.
Have you had enough time to talk to Mr. McLaughlin about this case?
Yes, sir.
Do you need any more time to talk to Mr. McLaughlin about anything involving this case?
No, sir.
Do you have any objections about how your case has been handled up to this point?
No, sir.
All right, Mr. Clark, do you freely and voluntarily admit the facts as set out in counts 1, 2, 4, 5, 6, 7, 12, 13, and 14 about how you violated your probation? Do you make those admissions here today, Mr. Clark?
Yes, sir.
All right, Mr. McLaughlin, go ahead and make your argument.
Your Honor, Mr. Clark is 51 years old. He has a terrible record. He's been in and out of jail, probably in and out of jail and prison, I think 7 or 8 times, always for drugs or drug-related offenses. He has done the prison RSAT. He's been, from talking to him and looking at his, our past encounters with him and the criminal record we had in there, he's been, I think at every level 5 prison except for Valdosta, and Ware. He, and I'm not trying to embarrass you, he has been on crack forever. And when he went to prison in 2014, he got hooked on methamphetamine in prison. Came out with a new drug of choice, and that's been the bane of his existence since then. Miss Stephanie Gotze got in touch with me, and Mr. Ronald Byers, who runs the, I can't remember if it's a Christian Recovery or Christian Family Center, but whichever one is the Thor-approved and GAR-approved one, sent me an acceptance letter for Mr. Clark. Me being me, I have no idea what I did with that acceptance letter, but I can get it emailed to the clerk. And Miss Gotze has kind of turned her life around. She came off everything she was doing cold turkey and basically told Mr. Clark here if he's going to have anything to do with her, he has to do the same, and he's wanting the opportunity to do that. I know he was on probation. I would encourage you to kind of look and see what happened in these violations. They all relate to drugs. He was taken to the jail and swallowed drugs, ingested them as he was going into the jail, which could have killed him. Fortunately or unfortunately, his tolerance is so high for methamphetamine that it did not. But I know that this is probably not relevant or germane to the sanction, but he is going. I just don't see him coming off meth if he goes to prison. I know he shouldn't be rewarded for violating probation. I would just encourage the court to maybe send him to some sort of, to the probation RSAT, suspend that upon him getting into and completing a private inpatient treatment center. He's never done that before in his entire life. I've never had the means to, and never had anybody that would actually help him get in there. He has some serious mental health problems. I know he's been diagnosed as having PTSD and depression. At one of his prisons, he was a witness to a stabbing death. Actually, I believe was called to testify in that case. And I know he doesn't deserve a break, but I think that's the only time that mercy counts is when it's given to the undeserving. Otherwise, it's just fairness. So I just ask the court to consider that. And if he does, I mean, I was candidly with Mr. Clark. I told him best thing I'd do for you is just go along and ask that they revoke the balance, because you'll be home faster than you would if you went to this treatment center. But
I was just sitting here thinking that exact same thought.
So he's not going to be doing much time, and like I said, I know probation is a privilege, not a right. But Mr. Clark ain't never had a break. He ain't never earned a break. He ain't never done what he was supposed to. He's been on drugs literally for as long as I've known him.
Ms. Stanley?
I have had a chance to speak with probation today and to look at his record check as well. And there are several different things that concerns me about that, which led me to my recommendation. It does appear, as Mr. McLaughlin said, that Mr. Clark has been on probation a bunch of different times. I'm seeing 10 different cases at the moment. I have spoke with probation. They have told me that he has already had several revocations on a case that is running concurrent with this one. There have been issues reporting. There have been, it appears, just repeated issues, all of the same things, which are receiving new charges, issues reporting, and things of that nature. At this point, I really don't think that continued probation or a continued program such as RSAT would be very beneficial. I'm concerned that there would be further violations if he were to go to a treatment program or anything of that nature. From my calculations, he has 1 year, 6 months, and 4 days left on probation on this case. I would ask that the court go ahead and revoke the balance to DOC for those reasons.
Mr. Clark, do you have any questions about anything that's happened up to this point?
Yes, sir.
Anything that you would like to say? You don't have to, Mr. Clark, but you can if you want to.
I would just like to say, I would, if I had a choice with this treatment, I know like my record reflects that I mess up and I mess up, over and over, but I do think I'm willing to try to get my life back on track now. I really do want a shot at rehab because I think it helped me out majorly, right? I'm willing to try it and give it my all. I promise I won't mess around with it. I'll give it my all, my best, everything into it.
Mr. McLaughlin, I haven't even looked at this petition. Are all of these counts in this petition, are they all just technical violations?
No, I want to be careful. I don't want to jeopardize my client if he's indicted for these charges, but
They're new charges.
Oh, there are new charges.
basically snatching
Oh, okay.
something
Well,
out of an officer's hand, a baggie containing drugs, swallowing that,
right.
possessing meth, swallowing the meth.
yeah, well, that's what I was afraid of. Okay. Let me get my findings out of the way before I forget it. Mr. Clark, the court finds that you have made a knowing, intelligent, and voluntary decision to waive your rights to a formal probation revocation or modification hearing. The court does accept your admissions to the stated counts as a sufficient factual basis for the petition, and the remaining ones will be withdrawn. Is that correct, Ms. Stanley?
Yes.
And now to the sentencing part, Mr. Clark. I don't have your full background in front of me. I don't have any reason to doubt anything that's been said by either of the attorneys or you, Mr. Clark. But I have to choose my words very carefully. And you have been incarcerated since August 21st, is that correct, more or less? August 21st?
August the 8th.
That was when?
I've been incarcerated since August the 8th.
Oh, okay. Well, Mr. Clark, I'm going to give away what I'm already thinking. I think I already did. Mr. McLaughlin has already brought it up. I have no idea what's going to happen or how your sentence or this revocation is going to be calculated. That's up to corrections and the parole board. I don't have anything to do with that. And if it didn't have these other, I'm going to just stop, Mr. Clark. I don't want you to think I'm throwing a bunch of rocks at you, but everybody in this room knows that you won't be there terribly long, but I don't know what's going to happen with these new charges either. So all I'm trying to tell you, Mr. Clark, is if you want to go to some sort of rehab facility, it won't be long before you get that chance. But I don't want you to feel like I'm just throwing you away or revoking your probation, which is what I'm going to do, and that I'm just sitting here throwing a bunch of rocks at you. You're going to get the opportunity, Mr. Clark, to do that sooner rather than later, but I can't in good conscience do anything but revoke the balance. So that's my ruling, that's my finding. Good luck to you, Mr. Clark, and I really mean that. Good luck. All right, that's it, Mr. Clark.
Okay, okay. We're gonna switch gears to, I think it's Texas. It could be Texas, possibly Texas. Um, and some pretty bad cases. The first two are especially, there's a minor in one of them. I'm playing it anyway. You can't really see him. He's way in the back, I think. He's only like this big. His face is only like this big. But holy shit, wait till you hear what he did. I mean, but first we have to get through another case first. And then we'll get to him. What? I am absolutely not muted. What do you mean you can't hear me? I wonder. But no, because it's going green. My microphone bar is going green. It's going the whole way up. Can anybody hear me? Is it 50-50 or am I muted? Okay, 50% of you can't hear me. I don't know what to do about that because 50% of you can hear me fine. Fuck it, I'm just gonna turn it up. I don't care. We'll see. I wonder. No. I know what the problem is. I think I know what the problem is. It shouldn't be, but I think I know what the problem is. No. Okay. All right. That's not the problem. I thought it switched to my stupid webcam microphone, but no, it did not. It did not. I'm going to make a small change. Does that make a difference? Before I go nuclear, on the setting I promised I would never touch, did that make a difference? I'm going to play court for a second so you can hear the difference. Wait, it didn't play.
Position 17, Antonius.
That's worse. Oh, guys, you know what? My new headphones has a microphone.
Orso.
There we go. I got it. Good? Can you hear me? Am I too loud? Am I too soft? Am I echoey? You should hear me. I wasn't muted, guys. I wasn't muted. I wasn't muted. Or I could have just unmuted. Yay means what? Yep. Nope. Not helpful. Yes. And yes, but am I loud? Am I soft? Because it's going red when I talk right now. Going bright red. Medium. Crystal clear. You're good. Now loud, but not bad loud. That makes sense because it's freaking maxed. It's going bright red. So I'm going to bump it down to here. Now I'm going to play the court clip, and I'm talking. I'm going to play the court clip. Just tell me if they're equal.
Good morning, Judge. Amanda Young for Mr. Orso.
Hi,
We're ready
Amanda.
for the bar hearing.
All right. Still very perfect loud, perfect loud, perfect loud, perfect loud. If you all could just get together on one of those words, that would be great. All right. I have a new head thing, and I got it at the dollar store. It has a microphone in it. So when I plugged it in, I don't know why it didn't pick this up, but it didn't use this microphone at all. It used this microphone, and when I turned this off, it wouldn't turn any of them on. The other ones were not on, even though I enabled them. I actually had to go into my graphics card and start broadcast from my graphics card and have that microphone on, which isn't a real microphone, to be able to get this microphone to turn on. I had to go into my graphics card to turn my microphone on there. Isn't that weird? Like, why? Why would you have to do that? Why? But that's what I had to do. So now I actually have two microphones running right now, but one is on my graphics card. I'll kill you right now. I'm not in the mood for you. All right. And I'm still trying to get chat to work. Now, I don't know if you heard me at all. I don't know if you heard what I said. We're in Texas, I believe, and I could be wrong. I don't know what state we're in. I have no idea what state we're in. Just gonna say Texas. It's probably right. And we got a 14-year-old. And I'm playing it. You can't see him. He's real tiny in the back of the courtroom. He sits in the back row, so you can't see his face or anything. But man, wait till you see what he did. But first, we have to get through a bad case first. So this is just bond hearing. We're not in a trial. We're not going to have a verdict. It's just bond hearing. Do they get bond or do they not get bond? Thank you again, Jude. Thank you so much, love. I appreciate you. I really do. Here we go. Texas, maybe.
And state's ready for position 17.
Position 18, Jameer Pearson.
Good morning, Your Honor. Andrea Schlissel on behalf of Jameer Pearson, and we are ready.
Good morning. Ashika Penn for the state. Your Honor, we're ready, and we also have a next of kin that is present on the line and wanted to be heard in terms of bond.
Position 19, Tyler Reed.
Attorney Lerner for Mr. Reed. We are ready to proceed.
Allison Lake for the state. We're ready.
Position 20, Lamorris Russell.
Your Honor, Teal Robbins for that position. My understanding is that we are having to request a continuance and are in the process of getting that filed right now.
Any objection from the state?
No objection from the state, Your Honor.
All right, I'll reset to the next calendar. Position 21, Cedric Smelly.
Yes, Judge. The attorney of record, Ms. Kyle O'Brien, filed a request for a continuance in this case.
No objection, Judge.
All right, that matter will be reset. Position 22, Ahmad Solomon.
Good morning, Andrea Schlissel again on behalf of the defense, and we are ready to proceed.
Allison Lake for the state, and we're ready.
Position 23,
Yeah, he's
Ernesto Tenero
Georgia.
Perez.
This is crazy that this is Georgia.
Proceed, Your Honor.
This is super crazy that this is Georgia because this is on YouTube. I got this off YouTube. I never get my Georgia judges from YouTube. They're other places. They're secret places. I can't tell you because you can only watch them here on Court Vibes. But this judge was on YouTube. And this judge is Georgia. And anybody could have watched him, but I only think like 7 people watched this stream, and he took it down right away. So you might only get to see this docket here today.
Ashley Trent for the state, Your Honor. State is ready.
Position 24, Xavier Turner.
Good morning, Your Honor. Kanisha Benz on behalf of Mr. Turner. We're ready to go forward. I would just ask, Your Honor, if possible, I need to make an announcement on another Zoom for another county, if I may be excused for about 5 minutes.
Yes, ma'am.
Thank you, Judge.
State's ready, Judge, on that one. Thank you.
All right, thank you. And position 25, Joseph Vina.
Attorney Lerner for Mr. Vina, and we are ready. Ashley Trent for the state, Your Honor. State is ready.
All right.
And this is my fault. I thought I had it at the beginning of the case.
Attorney Shive show up.
It looks like at some point trying to fix the speaker, I rewound it. For you young ones who don't know what rewind means, get a VCR.
Just ask, Your Honor, if possible, I need to make an announcement on another Zoom for another county, if I may be excused for about 5 minutes.
Yes, ma'am.
Thank you, Judge.
State's ready, Judge, on that one. Thank you.
All right, thank you. And position 25, Joseph Vina.
Attorney Lerner for Mr. Vina, and we are ready. Ashley Trent for the state, Your Honor. State is ready.
All right. Attorney Shive show up? Do not see him. All right, position 11, Leon Lewin.
Your Honor, if I could make a request as well.
Okay,
If we could begin, or if we could call Miss Penn's case just as soon as Your Honor is ready for that. I believe she does have some other engagements whenever Your Honor is ready for that case.
all right, we'll get Miss Penn right after we get this one.
Thank you, Your Honor.
Good morning again, Your Honor.
Good morning.
Yes, I am here for Mr. Lewin.
All right, and I believe that is Attorney Trin.
No, it's Maureen McLeod, Your Honor.
No, you're defense. I got you. I was asking about the state.
Yes, Your Honor. The state
All
will
right.
be representing Mr. or handling that case.
Yes, ma'am. If you can give me a little background, facts, and criminal history.
Yes, Your Honor. Your Honor, he has been in custody for 25 days. He was arrested on August 15th on this case. He is currently in custody without a bond. That was a bond that was set at felony first appearance by Judge Kemp, Your Honor. The incident, as far as the facts of this case, on August 15th of 2025, Your Honor, the victim was driving on the highway with her kids in the vehicle. She was driving away from the defendant. The defendant was in his truck when the defendant tracked the victim down on the highway. The defendant was able to take the kids away from the victim's car, placing them in his truck cab, and then began to drag the victim out of the victim's car towards the truck. The victim was fighting the defendant's efforts to drag her, and so the defendant struck the victim across the face repeatedly in order to get her to comply. When the victim continued to resist the defendant then drug her by the arm and her hair to his truck. The kids who were in the vehicle were able to observe the defendant attacking the victim, and they were crying out, "Stop hitting mommy." The defendant eventually dragged the victim into his truck seat. The victim tried to exit the vehicle, but the defendant tied a truck strap or rope around the handle in a way so that the victim could not exit the vehicle. The defendant then drove the group, which was the victim and the children, to the defendant's father's home, despite the victim expressing that she did not wish to go there. The victim had to cooperate for a while with the defendant so that the defendant would allow the victim to sleep inside the truck. The defendant then eventually agreed to return the victim to her car so that she could drive her and the kids to her mother's home so that the kids could stay at the mother's home instead. The defendant, however, drove the kids in his truck, and the victim followed the victim as the victim drove herself to the mother's home. While the victim was driving her car to the mother's home, the victim was able to call 911 and have officers meet her at the mother's home. Law enforcement officers arrived, and they saw the defendant sitting at the apartment steps outside of the mother's residence. When law enforcement officers were speaking to everyone, the defendant did admit to striking the victim multiple times and dragging her to his truck and trapping her inside with a rope, but he said it was because she was having a mental health crisis and was exhibiting signs of self-harm. The victim denied having any signs of mental crisis, and when the officers were speaking to her, she sounded completely clear, composed, and sober, and this was also evidenced by the 911 recording that they were able to listen to, Your Honor. He has no criminal history, Your Honor. We have been able to speak to the victim. She is highly opposed to bond. She is extremely fearful for her safety and for the kids' safety, Your Honor. She is not at her home right now. She's explained to us that the physical abuse over the past year has escalated. She has expressed to us that he is verbally and financially abusive to her. She's expressed to us as well that as of yesterday, she no longer has access to any of her bank accounts, that the defendant is the primary breadwinner, that she gave up her career to stay at home and be a stay-at-home wife, Your Honor. She also explained to us that the defendant has isolated from the family and the friends, that he has always been abusive to her in front of the children, that he's also from Jamaica, and that she's fearful as well since she does believe that he is a flight risk. She's also explained to us that she's additionally fearful since she does believe that his family has hired a private investigator, and she kind of believes that she might be being followed a little bit. And she's also afraid, since she fears that some of her email accounts might have also been hacked. But she is extremely opposed to bond, Your Honor. She's also explained to us that he's a truck driver and that he does travel around the country, or that he drives a lot, and that he does have the resources to flee the jurisdiction. The state's recommendation, Your Honor, is that Your Honor deny bond. We do believe he's a risk to intimidate, that this is an intimate relationship between these parties, and that there's an extremely vulnerable nature between the victim and her children. The defendant has exhibited all types of abuse, and especially given the facts of this case, Your Honor, and that the victim has explained to us that there's a history of abuse as well. And that these incidents have occurred specifically in front of the children. But the state's recommendation, Your Honor, is that Your Honor deny bond.
Attorney McLeod.
Yes, Your Honor. My client is 31 years old. He has been living in the state of Georgia since high school. He actually went to high school and has 3 years of college, and he has resided in the state of Georgia more than half of his life. Your Honor, these parties are actually married and they share 4 minor children, the youngest of whom is only 10 months old. My client has no kind of criminal history whatsoever. He is a family man. As I said, they share 4 minor children. He tells me that there have been some issues concerning alcohol abuse, and also there is a mental health diagnosis with respect to the alleged victim. He tells me that on the day of this incident, he was he tells me that the alleged victim was highly intoxicated, and that the situation, she was driving with the children and it was unsafe. This was a situation where he was just trying to protect the children and also trying to protect the alleged victim, Your Honor. As I said, there's never been any history of any abuse or anything. Both of them are married, as I said. They are in church. I was able to speak with their minister, who has been counseling them for a while as a couple because of some of the issues that they were having in their marriage with relationship to the alcohol and the issues that sometimes come about as a result of the mental health situation. And the minister is on the call as well, Your Honor, and he is prepared to testify to the court. Also, my client's parents are on the call. Given the fact that of what he's charged with, Your Honor, I believe that he's entitled to a bond. He has no criminal history, 31 years old. And if he had been, what they're trying to say is he would have had some kind of record. He does not. He is a truck driver, and the state is correct. He is the primary breadwinner in this family, Your Honor. And therefore, minor children sitting around now with no means of support. My client needs to be out so he can take care of his children. That is his biggest concern. Any kind of bond can be conditioned on no further contact with the alleged victim or no further violent contact with the alleged victim, whatever the court thinks is most appropriate. But we would definitely ask for, if not a signature bond, Your Honor, for a very affordable bond, because keeping this young man locked up away from his children does not serve anyone. I had attempted to speak with the prosecution so I could give the state some background so that they could perhaps investigate a little bit further, because as we all know, Your Honor, sometimes everything a victim says does not reflect the true situation as it has been happening. They've been knowing each other since they were in college together, and they have been married now almost 10 years, I believe, Your Honor. As I said, they share 4 children. I believe that the alleged victim has been having some issues with postpartum depression. That's what I have learned from speaking with not only my client, but with his family and also with the minister for their church, Your Honor. So I'm asking for a bond for him at this time.
Attorney Tran, if I was to grant bond today, what conditions would the state be asking for?
Your Honor, we would be asking for no contact with the victim. We would be asking for ankle monitor, Your Honor, and house arrest with that he reside at a particular location. Of course, with those exceptions to allow him to be allowed to work and go to court and meet with his attorney, as long as he submits his schedule prior, report pretrial services within 48 hours, Judge. No alcohol or drugs, no firearms as well, Your Honor, but those special conditions, Your Honor. And then, of course, I know counsel is asking for a signature bond, but these are bail restricted offenses. I just wanted to make sure the state touches on that matter as well.
This time, the court's going to order a bond in the amount of $20,000. He's going to be on ankle monitor or house arrest. He's going to be able to go to work. He's going to need to provide his trucking schedule to pretrial services. He's to report to pretrial services within 48 hours of being released. Then he's also to be able to go to medical appointments, meet with his attorney, the standard conditions for it. No contact with the victim, no violent contact with the children. And,
Thank you, Your Honor.
no firearms or possession of any illegal drugs or non-prescribed drugs. Let me say that.
And I'm so sorry, Your Honor. Did you say alcohol as well?
Yes, ma'am.
Thank you, Your Honor.
All right. Do we have an address form of Attorney McLeod? If you can provide an address to Attorney Tran.
I will, Your Honor. I will definitely do that.
All right. Anything else?
Nothing further, Your Honor. Thank you very much.
All right.
A note on her door. She's sitting there by the back of the courtroom.
All right. Attorney Penn, your case was position 18, Jameer Pearson.
Yes, Judge, that's correct. Is Miss Schlissel? I can't see.
I see her.
Okay. And Miss Carmen Givens. Okay, I see her. Right, Your Honor, this is position 18, Jameer Pearson. Mr. Pearson is 14 years old. The incident date is July 24th, 2025. He was arrested on August 7th, 2025. The incident location is 621, I think it's Walting Way in Stone Mountain. Mr. Pearson is currently in custody with no bond on felony murder charges. The victim is a Deontay Brown, who was 17 at the time of his death. And as stated before, the next of kin, his mother wanted to make a statement at the conclusion of my summation, I guess. On July 24th, 2025, officers responded to a person shot call at the incident location. Upon their arrival, they found an unknown Black male, later identified as the victim, who had been shot multiple times inside a car. He was located in a red Chrysler 300 that was against a tree at the front of the apartment complex. The victim was unable to speak and was taken to Grady Hospital, where he was later pronounced deceased. Officers spoke with a witness who was also the 911 caller, who stated he observed the shooting. The witness saw the victim sitting in his car when he saw two males, one with a black hoodie, one in a gray hoodie, began firing shots at the car. The witness also observed the car continuing to move until it hit a tree and ultimately stopped. He saw two of the males crouched behind different cars, shooting at the victim's car before the car struck the tree. The suspects then ran around an apartment building, approaching the stopped car from a different side, put on ski masks, and shot about 3 more times. Then they reached into the victim's car and took a black book bag and ran away. The witness did not realize until he looked at his security camera that there were actually 3 males that were walking toward the victim's car. The video shows the 3 males walking toward the car, but they don't show the shooting.
Now, in another minute or two, right at the end of her talking, the video jumps. I don't know how. I don't know why. I wasn't even near my computer when this was recorded. So it had to be in the YouTube video itself. But we missed the very end of what she says. And I really wonder what she said there. But that's okay. We already got the gist of it.
Witness stated that he had seen the three males together before walking around the apartment complex smoking. Detectives found 2 clusters of shell casings and a few shell casings near the victim's car. It appears the victim was shot at least 14 to 16 times, and there appears to be at least 2 different guns used. Detectives then met with the property manager who provided additional surveillance. There are multiple videos, and they show the 3 males walking through the apartment complex, again, up to when they are approaching the victim's car, but not the actual shooting. On surveillance, suspect number 3, which the defendant has been identified, is seen running between buildings 615 and 621. And the surveillance shows after, I'm sorry, I messed up, Your Honor. Okay, on surveillance, the defendant is seen running through the buildings toward the end of the shootings, and surveillance shows after the taking of the victim's black book bag, the other 2 suspects are seen running in that direction as well. The apartment video surveillance goes on to show the 3 males going back to the breezeway of apartments 1 through 4. Surveillance also shows that after the shooting, 2 defendants, suspect 1 and this defendant, are walking through the breezeway. Suspect 1 is seen carrying what appears to be the victim's black book bag to the rear of the breezeway. Sometime later, the 2 suspects, including the one before the court today, are seen leaving together in a black Nissan, and they no longer have the book bag. Maintenance workers were able to identify apartment 3 to be associated with one of the suspects because about 15 minutes prior to the shooting, surveillance showed one particular maintenance worker working in that area, and he stated that he saw the 3 males together. A search warrant was obtained and executed on August 7th of apartment number 3. The apartment belongs to the defendant before the court, his mother. After showing still photos from the surveillance video, the defendant's mother identified her son, Jameer, as the person in the gray jogging suit. Additionally, when the defendant's room was searched, detectives found the clothing and shoes Jameer had on from the date of the incident. Jameer was detained, and his mother gave the police permission to speak with him. He was transported to headquarters to be interviewed. Prior to the interview, he was read his juvenile Miranda rights, and he chose to speak with the detectives. He initially denied involvement, but ultimately confessed to being at the shooting, but not being the shooter. He identified additional co-defendants as Nardo and Trey. After speaking to the defendant, officers were able to determine a bit of a timeline of events because they were able to go through the victim's phone, and they also have received a number of Instagram messages. Detectives found the victim's phone in his car and saw that the last contact the victim had with anyone was a Telegram audio call minutes before the shooting, and it was from a particular user. The defendant appears in a message group with that person with that same username. Late night, July 23rd, which is the night before the shooting, and into the early morning of the shooting, the defendant is communicating with a now identified co-defendant, Nuruddin Amin. Nuruddin's nickname is Nardo, and Nardo was arrested this past Thursday, September 4th. There are messages going back between the defendant and Nardo about how many pens, meaning vape pens, they may get. Are they still doing that thing tomorrow? What time are they doing it? And how many of us are doing it? Through Instagram messages, detectives found messages from Jameer's account where about 4 hours prior to the shooting, he is sending messages to multiple people that he was going to take down some pens, again, vape pens. Vape pens are being used for moho, some synthetic weed, and the victim was known to sell weed and have access to pens. Jameer is also communicating with someone and it's saying we got to see when he's going to push up. Jameer is making FaceTime calls to the co-defendant Nardo and the third co-defendant, I cannot pronounce his name, Deviat Rakundo, who is nicknamed Trey, who was also arrested this past Thursday, September 4th. They were all communicating throughout the time prior to the shooting and after. Additionally, the day after the incident, July 25th, around 5:30 in the morning, Jameer is messaging with someone saying, "We caught an N-word with his pants down." Then starts to talk about what appears to be the contents of the book bag, speaking about how many pens he now has, and mentioning a gun, which officers believe the victim may have had in the car while trying to sell the pens. This is a 14-year-old, Your Honor.
Swear in. Ms. Gibbons, your camera on?
It says it is. Oh, wait a minute. Let me
There we
open
go.
it. There it is.
Okay, Ms. Givens, if you raise your right hand. Do you swear or affirm the testimony you give today will be the truth, the whole truth, under penalty of perjury?
I do.
Okay, and please state your name for the court.
It's Carmen Givens.
Okay, and Ms. Givens, if you give the judge some insight about what you think about the defendant receiving bond.
Good morning, Judge. I'm here today as a mother and an officer of the law, asking the court to deny bond to this defendant. I started my career working in DeKalb County Jail, where I witnessed, a lot of youth males coming in with serious charges and would try to them, but some of them you can get through, some of them you could not. But having a son, I just felt like I needed to, try and talk to these kids to give them some insight on making better decisions and not, coming back and forth to the jail. But, today we're not here because of a mistake or a youthful error. The defendant, though he is a juvenile, he's charged with murder, which is one of the most serious crimes here in Georgia. This is not a lapse in judgment that can be excused by the age. This is the intentional taking of a life. By committing this act, the defendant has already demonstrated a capacity for violence far beyond what the society can safely overlook. The violent nature of this offense poses an undeniable threat to the community if the defendant is released. As both a mother who knows the value of a child's life and an officer sworn to protect and the public, I cannot ignore the danger he presents. And for this reason, I'm respectfully asking that you deny the bond.
Thank you, ma'am.
And Your Honor, just to close, the state does believe that the defendant poses a significant threat or danger to a person, to the community, or to any property in the community. This is the same neighborhood in which the victim lives. This was an incredibly violent, premeditated attack. The victim never made it outside of the car, but he was shot at 14 to 16 times on both sides of the car. And where the defendant has said that he was there, but he wasn't the shooter. At this point, the state we haven't been able to ascertain exactly who the shooter is. But what we do know from the evidence that we have thus far is that the defendant, at the very least, was part of the planning of this attack and also was trying to benefit from the fruits of the crime afterwards. Secondly, the defendant does pose a significant risk of intimidating witnesses or otherwise obstructing the administration of justice because, again, this is the neighborhood in which he lives. The only witnesses to this crime are neighbors and workers of the apartment complex. So if the court were inclined to give any sort of bond, the state would request that he not live in the place where the incident location was. So he would also need probably another supervising adult.
Attorney Schlissel, do you have any questions for Ms. Gibbons, first of all?
I'm sorry. No, thank you. I'm sorry for
All
your
right.
loss.
Thank you, Ms. Gibbons. You can turn back off your camera and go back on mute. Go ahead, Attorney Schlissel.
Thank you, Your Honor. Your Honor, Jameer, as was stated, is 14 years old. He resided, prior to his arrest, he was residing with his sister, a 16-year-old, 11-year-old sister, a 4-year-old brother, a 3-year-old sister, and a 2-year-old brother. He was just about to start Stone Mountain High School in 9th grade. He has not had any prior contact with the juvenile justice system. He has not had no prior arrests, and has not had significant behavior issues at school, as far as I know. He was actually the following day was about to have a physical done so that he could try out for the football team at the school. Your Honor, he has intentions of going to college after he graduated from high school. His mom explained that he's extremely helpful in the home and the neighborhood. He would help taking out garbage for neighbors, and he was also working at a barber shop helping sweep up the floor and other little things that they needed help with. Your Honor, we would submit that based on the Ayala factors, he is not a risk to a flight. His father and family all live here in Georgia. He has no prior history, and would be able, if the court would consider granting him a bond. His mother has identified his maternal grandmother, who lives in Atlanta, away from this neighborhood, because his mother also does not want him to return to the apartment complex where all this happened and where these other youth and their families also reside. So we would also be in agreement with no contact, as well as not returning to that area. Your Honor, we would be asking for a bond in the amount of $25,000, based on the Ayala factors. And at this stage, there is no indication, although it sounds like there's some indication that he may have been involved in some intention to commit a robbery. There's no indication that there was an intent to commit an armed robbery, or for him, for his participation in the shooting specifically. But as for the Ayala factors, we would be asking for a bond in this matter. Thank you.
At this time, the court's going to find that he's a risk to intimidate witnesses and a danger to community and persons, and deny bond.
Thank you, Your Honor. That is my business. May I be excused?
Yes, ma'am. Attorney Taylor, I don't see your name on this calendar.
Judge, I just was retained on Marquez Kimbrough.
All right, we'll get to you in a second. All right.
Thank you, Judge.
All right, position 17, Antonius Orso.
All right, we made it to the end of that one, that horrible one. Guys, thank you so much for coming out today. I really appreciate it. I was not able to get Twitch working. I worked on it the entire stream. And then I found out at the end of a stream that it's a known bug. No matter what I did, I wasn't going to get it done because it's a known bug. So I need to redo the whole thing. But it's fine. It's fine. We at least got a microphone working a little bit today. I ignored you all the whole stream because I was trying to fix it. I'm sorry. I'm sorry if I missed anything anybody said to me. I don't know because I was working so hard on Twitch. But you can talk to me in Discord at any time. I'm always there. Or if someone's talking to me, I'm there. I'm not just sitting around all day waiting for messages. But if there are messages, I will reply. I'm going to set up OJ in a few minutes and I'll see you all there. Bye, guys. Oh, wait. There we go.
Well, I thought I'd write a happy song. I found a chat room where I belong. means to me. With such a groove, I'm less lonely. Oh, Kathy's the creator, she's leading the way. At Court Vibes, we laugh and we stay. Her smile shines bright, she's got that grace. Come join the fun, it's a welcome and play. I can count on distraction from my pain, 'cause this creator takes you there and back again. Kathy is the heart here, always in stride. Her work is hard, but her joy she can't hide. Oh, Kathy's the creator, she's leading the way. At Court Vibes, we laugh and we stay. Her style is classy, she's always top shelf. Don't take my word, come and see for yourself. Her cases are new with a twist or two. I really like them, I believe you will too. A little lifeline passed along in rhyme. Why don't you join us? It's a guaranteed good time. Oh, Kathy's the creator, she's leading the way. At Court Vibes, we laugh and we stay. Her smile shines bright, she's got that grace. Come join the fun, it's a welcoming place. And so in conclusion, I'll wrap up this song. I hope I didn't miss anything that would be wrong. Hope I see you around. Don't stay on the shelf, join in the laughter. Come and see